There's about 4 or 5 videos that are there. The links are on the D2L page. This lesson is there. I'm not going to show those videos during this class. I encourage you to look at those videos because anything in those videos may come up in a quiz or something like that. So do have a look at the videos, have a look at the links. But I'm going to restrict my discussion to the non-video things. Okay? So intellectual property is the overall idea of today's lesson. And so that includes things like copyright, patents, trade practices, etc. Now, intellectual property is often just abbreviated to just IP. So if you see that, some of you might have done a bit of hardware studies as part of your IT degree, and you'll have used a different IP, be aware of that. You might be reading an article somewhere and you'll see IP and you start thinking about computer networks. Well, most people actually think of intellectual property. If you're talking to a lawyer and they say IP, they're going to be talking about intellectual property, all right? Only network administrators talk about IP as being, IP addresses on your network. Does that make sense? So we're not talking about IP addresses on the network. We're talking about intellectual property if you see IP. So this slide is just making the point that IP recognizes people's creativity coming up with something new and unique that's developed by a person or persons. That is their property, and that is their intellectual property. So if you draw a picture, if you paint something, if you write a song, if you perform that song and you record it, that is your property and you have the rights to it. You can do with it what you want, you can sell it, and other people cannot without your permission. So that's what we mean by intellectual property. Certainly, please do. I'm sorry that I didn't. And so I mentioned it extends to music and books and anything that you might write, but it also extends to software. So if somebody creates a software package, they have the intellectual property right to that. Now, how that's protected, as it says here, we have our main ways here, which is copyright. Copyright is kind of implied. You can just state that I claim my copyright rights to this thing that I've created. Patents, that's a little different. With patents, you actually have to go and make an application to get patent protection. And patent protection is limited by time. And as far as I know, and I could be wrong on this, but as far as I know, it's certainly in our lecture notes, it references the United States Patent Office. I don't know any other country that has patent office. If there was one, it would probably be in the Anglosphere. What I mean by that would be Britain, Canada, Australia. I don't know that they have a patents office. I think it's just the United States Patents Office, but certainly like countries like China, they don't have a patents office. And a lot of people working in those countries might not recognize US patents. And so US patents is what we're talking about in this lecture mostly. And what that means is that your idea that you have patented is protected within the United States. And so what I mean by that is you might go to China and you'd find that your patent doesn't give you any protection in China. So now copyright, on the other hand, that's kind of universal. And trade secret laws are also come into, if you want to call them law, by inference, right? If you have a secret way of doing something that's part of your business, that's protected without you having to go and make a big application. All right, so let's talk about those. Copyright. As I said, copyright can be implied. You can put that onto your website. Just put a little copyright symbol under there. You don't need to make a big application like you do for a patent. And you can, having said that, you might find yourself in court, and people do find themselves in court because they have created something and then they look and they say, oh, so-and-so is using my stuff. So now I'm going to sue them, and I'm going to sue them under copyright because they're using my intellectual property. You might have seen this recently. So you guys are young. You might, who's that guy, that really white guy from England? Styles, is that his name? No. Sheeran, Ed Sheeran. You guys know him? So he just spent a lot of time in court because he wrote some music and there was some bars in the music that were somebody else said, oh, that's my music. And so Ed Sheeran had to take him to court. Or there's a lot of money involved in that. The other one that for older people like myself, so the Beatles was Paul and George and Paul McCartney, John Lennon, and Ringo Starr. So it was George Harrison. He wrote a song that was called My Sweet Lord. I don't know if you guys ever heard that song. But anyways, his song, My Sweet Lord, I'm not going to sing it for you. But anyways, it was a very sort of repetitive, sort of very nice kind of song. But an artist from like 20 years before that said, well, you know, these bars from that song came from my song. So he was in court for a long time. So it's happened a few times just with music. And as I said, they didn't have to go and register with the US patents or anything. They just got their music out there and then they had a problem with it. Now, when I first started using YouTube, you guys know I have a YouTube channel because I put my lectures onto my YouTube channel. Well, when I first started using YouTube, I used it to do less professional things, you know, like riding around on motorcycles. And, you know, I'd put music to it. And how many times this happened to me? It happened to me a few times, but I'd put the video up and YouTube would take it down. It'd say, you can't use that music. All right. Yeah. So it was, you know, music I liked, you know, Bon Jovi or something. Yeah, just heads up, you can't use Bon Jovi. All right. So he protects his copyright. So you end up in YouTube, if you want to use somebody's music, you end up using some emerging artist, you know, somebody who's not famous and they don't mind you using their music because that's, you know, getting their music out there. And so I just don't put any music. Yeah, then you don't break anybody's copyright, right? So the problem is, right, you can do that a few times. Use Bon Jovi there a few times, they'll block you. And if you keep doing it, they might sort of close down your YouTube channel. You know what I mean? So that's protecting copyright, and fair enough. I got no problem with Bon Jovi protecting his copyright. You know, it's his music. Go for it. So if you break copyright, yeah, I mean, are you going to get fined? More likely, you're going to end up with in a legal dispute with the owner of the copyright. And as I said, that could be a lot of money. Ask Ed Sheeran. Yeah. Yeah. Now we do have this thing called fair use doctrine. Thank goodness. Okay, so you guys who have clear eyes and sort of see things, look at the bottom of the screen on these slides. And at some point you'll see a little copyright and it'll say, you know, this slide, this is owned by the C Engage company. No unauthorized copy or whatever of this is allowed. And you might say, oh, well, what are those guys doing at the university? I mean, you know. Okay, so we have to buy this, right? And we have to buy it and we have to ask for permission to use it. So these slides, I will admit to you, it wasn't one of our staff who sort of made up these slides. The slides come with a textbook, which we buy permission to, and then we use it. And so it will be copyrighted. And if you look carefully, you might see a copyright notice at the bottom, which basically says that random people can't go out and do it. Now, what does that mean? So I might set up a private company where I'm going to teach people about copyrights or something like that. I don't know, about the stuff in this topic, about ethics. And so I find online by doing some things, somebody's got a sort of pirated copy of the textbook and all the slides and stuff like that. And I set up a company and I start teaching people about computer ethics and I use all of that stuff. Well, yeah, I'd probably end up in court somewhere right now. How do we not end up in court? Well, first place, we bought the stuff, right? And then the second place, we're using it for educational purposes. And that brings me back to the fair use doctrine. You can use, you know, up to like a chapter from a textbook without sort of infringing upon copyright. You can certainly use a page or something like that if it's in an educational setting. So it's not like random people can use it, but if you're using it for education, there's a bit of a slack on that. Otherwise, every college, university, high school, primary school, certainly in the United States and in many other countries, would be ending up in court all the time because they're all using stuff, right? So it's definitely, you can use a little bit of stuff, but in fairness, what you should do is you should make a reference. You should say, this material belongs to so-and-so, and we used it with permission. This is where we got it. We're not sort of pretending that we made it up in our own, because that's not right. Does that make sense? So we do have this idea of fair use. And now I mentioned it in education. It's a big deal in education. If any of you ever get a job as a teacher or something like that, you might find that your first couple of days on the job, what we call the onboarding, you're going to have a lot of sort of, the induction will happen. And part of that induction, you'll probably have a workshop where they talk about copyright, and, don't do this and don't, if you, so, I mean, terrible abuse of it would be, all right, so we're talking about 30 years ago, you found somebody's textbook and you photocopied the textbook off and you gave a copy to all your students. That's bad. You're going to court, right? I mean, it doesn't matter if you're in a primary school or a high school or a university, you can't do that. I say, bringing it into the modern age, I did a bunch of Googling around. I found this dodgy site that had a PDF of all of the textbooks. And I got that PDF and I put a link to it. And I gave that link to all my students. And that would be breaking copyright. All right. Now, on the other hand, if I said to my students, I think, okay, use your initiative, find the materials where you can. Well, that's your problem, right? I don't know. I think you could probably find just about any textbook. Somebody's done a PDF on it, and they're breaking the law, probably. So, as I said, who needs a whole textbook? Use a chapter. You're probably going to get away with that, but don't make a copy of it and sort of distribute it. All right, so there's these three different ideas. These are three different ways of doing intellectual property. Copyright, I've mentioned a little bit of it. And what it mentions here is that, so the World Trade Organization has an agreement that covers that, but software actually can be covered by copyright. You can copyright your software. You make something that's a unique, creative contribution that's made by you, and therefore you have the right to it. Anybody who's making money out of that, well, that should be you, or some of it should come back to you. Now, a patent is pretty clear. You either have a patent or you don't. I mean, it's pretty clear how the patent thing goes, because you have to go to the US Patent and Trademarks Organization, and you make an application, and they agree to your application, and then your idea, which you patented, is protected, but it's protected for a limited time, protected for like 15 years. Oh, did I mention copyright is also protected for a limited time? I guess we're going to come up with that in a couple of slides here, but copyright doesn't go forever. But it usually goes until after the person who created the whatever it is dead, right? So if you have a copyright, nobody can do your thing as long as you're alive. But so, like I mentioned, the Beatles. Are any of those guys still alive? Yeah. Okay. So we can't really use their music. But okay. But Bill Haley, I don't know. He died in a plane crash in 1956 or something like that. I think I could use his music, because it's they got to like 50 years after they're dead. Their copyrighted material is protected. Okay, you probably heard of William Shakespeare. He wrote a lot of plays. I can go and do William Shakespeare plays everywhere I want. I can write books on William Shakespeare. I can do anything I like with William Shakespeare, because he's been dead for 500 years. You know what I mean? There's no copyright on his material. You can use that. If I want to publish a website which just has William Shakespeare stuff on it, I can do that. No problem. And I don't have to pay anybody, because he's dead. Does that make sense? And it's not just that he's dead, it's that he's dead a long time ago. The guy that just died yesterday, that's still protected for like 50 years after they're dead or something like that. So you have to pay their estate to use their stuff. All right. So the patent I mentioned, you have to make a application. It says there discrimination is not allowed on the place of invention. So you could invent some nice idea in China. So I mentioned China doesn't have patent laws as far as I know, but you could invent some idea in China and then you could run over to the US or send your representative to the US and patent it in the US, and that'll protect it in the United States so nobody can use it except you in the United States. Trade secret, the idea there is you've got some special way of doing stuff. I guess a famous one would be, oh, they always talk about it, Kentucky Fried Chicken, right? Secret recipe of 11 different herbs and spices. Well, I'd like to know that. Okay, so one day I go along to the Kentucky Fried Chicken store and I have a look and I find out those 11 magic herbs and spices. That's illegal, right? If I go and take that and I go and make, Indiana fried chicken with the same recipe, yeah, I have broken a trade secret because I'm not supposed to do that. That's their special thing. And they don't need to patent it or anything like that. And so we have this idea of industrial espionage. That's where people are stealing other people's ideas. And yeah, it's against the law. All right, so we got this thing about the digital medium. So WIPO is protecting informational, the worldwide, I think, intellectual property organization. You can Google that. But basically, what it's saying there is your music things, they're all protected through that. And that also applies to our software. So a little bit more on the patents. As I said, as far as I know, it's really exclusive to the United States. And so that's why we go to the United States Patent and Trademark Organization, and we put it there. Some things can't be patented. You could be a really smart mathematician and come up with a new formula, mathematical formula, because that's totally abstract. Mathematical formula that you think solves all kinds of things. That's an abstract idea. Can't patent it, sorry. Or some new philosophy or something like that. As it says, laws of nature, natural phenomenon. Have you heard of Monsanto? Monsanto. So, there's lots of sort of the conspiracy theory people, they all talk about Monsanto. Not all of them talk about it, but many of them talk about it. And so why is that? Because Monsanto is quite, what's the word I'm going to say? They have a lot of controversy surrounding them as a company. There's a lot of people don't like Monsanto. And some of the issues that come up with Monsanto is farmers who've been poisoned by Monsanto's very, very effective Roundup weed killer product. So the Roundup weed killer product will kill all broadleaf things. So that's good if you have a farm where you just want to have narrow leaf things like grain. So that kills weeds really, really well, but it also kills farmers apparently. And so that was a bit of a controversy. The other controversy is that, and you can find this, there's a lot of court cases going on about this, is genetically modified foods, GMOs. So Monsanto is a big deal in the genetically modified foods. And so there's a lot of court cases based around that, because what they'll do is they have genetically modified seeds, and not just food, seeds. So you have to, these seeds are pretty good, I guess. And what they've been doing is they've been suing farmers that they found out that the farmer had that particular seed and they were using it on their farm and they hadn't paid for it. So, I mean, I don't know where they got it from, because as far as I know, the seeds are not fertile. I mean, they'll grow something, but then you won't get another crop. But they'll sue you for that. And, of course, there's I guess the idea of that is, are we doing this? Is this something to do with the law of nature or a natural phenomenon? Because seeds, we're talking about DNA, you know what I mean? Can you copyright, you know what I mean? Can you copyright that? Can you put a patent on it? And so like Monsanto says, yeah, that was all right. We're the first ones to do that. So, we own it, you can't. So where do we go from that? Because you may have also heard of a thing called the CRISPR Project. I mean, it is possible to, the CRISPR product, the idea there is we can build a better human by sort of fixing the genetic defects that are in us. Okay, so then what are we gonna do? We're gonna patent that, we're gonna copyright it, and then maybe that human is gonna be owned by Monsanto. All right, so just forget it. I said all that stuff. Patent infringement. So if you do, if somebody owns a patent and you reproduce their idea in some way and use it and make money on it, yeah, you're going to court. I mean, you can, and they will be able to use quite a lot of power to sort of get that for you. Now, this idea here that's mentioned is the U.S. Patents Office has been there since the 1800s. And a lot of people would say that the U.S. Patents Office was part of the reason why the United States became a superpower, because during that time when they were developing their economy so much, the U.S. Patents Office was receiving all these patents on which the American industrial system was able to sort of produce things that people couldn't do, even though in other countries they don't even have the patent and they might just do it anyways, right? But the patent law has changed a bit. We see that they brought in a new law in 2011, which made it a bit harder to get a patent. But what that means is that the patents that they have are a little bit stronger. Yeah, it's so, and also the thing is, it's about first to file rather than first to invent. So two people could have the same invention, and whoever makes it down to the patent office first, they're the one that's going to get the patent. So can we have a software patent? Yes, we can. You can get a patent for your thing, that whatever it is, software that you've designed. Now, the next little paragraph there, I think that's also a little bit controversial. So have a look at that. The idea being that two companies could talk to each other and they could say, well, you know, you got some good intellectual property and patents. We got some good intellectual property and patents. Let's sort of get together and sort of we'll share the ideas. And the idea being here is that's typically going to be your larger companies. And so your smaller companies are going to be at a disadvantage from that. So basically, it could be seen as a way of developing I'll call it a pseudo monopoly. I mean, all businesses, if any of you study any economics or business management or everything, you'll, especially in economics, you'll learn pretty quickly that what businesses seek to do is they want to have a profit, ability to make a profit that other people don't have. The best way to do that is to get a monopoly in some way. Now, if the government will give you a monopoly, awesome. That's the easiest way to get a monopoly. Another way to get a monopoly is you can just have a monopoly of some kind of technical advantage. And so that's what the patent is trying to get you. And so if you have very large companies and they've got lots of technical advantages, which they've patented, the more they get together and become bigger, the more that monopoly power they have, which is, monopoly is a way to make more profit, really, because there's less competition. Competition tends to drive down the profits. So that's kind of bad for startup businesses because they're not going to have that kind of power. And so, yeah, people say, I mean, so let's talk about Bill Gates, right? Bill Gates was at one point the richest person in the world, and now he's not, because I don't know who it is. Who is it today, right? I think it's Elon Musk, right? It depends on what the share price of Tesla and SpaceX is, but Bill Gates was at one point. And how did he become the richest guy in the world? Was he the only company that made good software? No. Did a lot of this stuff, right? Sort of basically getting monopoly power, forcing out other software, some of which was actually better than the stuff that arguably better than what the Microsoft was producing, but getting that kind of monopoly advantage, and therefore you could, yeah. So I mean, Word. Are there any? The Microsoft Office. Are there any alternatives to Microsoft Office? Yeah. Are you using them? No. Right, because you know we're all paying $100 a year to Microsoft to get our Microsoft Office that we're using on our computers, because where else are we going to go, right? Well, you could. I mean, if you had a philosophical objection to Microsoft and you just said, you know, I really don't like Bill Gates, I'm not going to do that. You could do that, but you might, and you could do it without paying $100 for a suite like Microsoft Office. You could get it. You could install Linux onto your computer, and then you could buy Linux tools that look just like Microsoft. But you'd probably have to have a level of technical expertise, which is higher than your average user, because you know those are going to be free tools, and you know if you can get support from them. For a company like Red Hat, they'll give you support, but they're going to charge you. And so I mean, you're not going to be, you maybe not going to save any money, and you have to train yourself how to use them, and you won't have Microsoft support. And so yeah, Shahid. Yes. It's free to use for a little while. I mean, I don't know how you've done it. If you downloaded a free package of Microsoft Office, yeah, there's a trial package that you can use. Yeah, but I'm paying $100 a year. All right. Talk to Shahid. She's got a free way of using Microsoft. I don't. Okay, so enough on that. Trade secrets, as I said, with that, you don't have to go to a patents office. Your trade secrets are things that you do in your company that you think is not generally known by the general public. It has to be that. If it's generally known by the general public, it's not a trade secret, right? You must have put some effort into creating that idea, and you must make some effort to make sure other people don't know it. And if you've done that, then it can be recognized as a trade secret. And if somebody else bobs up with it, then you can sue them, I guess. All the fun things happen in court, right? So the cool thing about trade secrets, as it mentioned here, is there's no time limits on it. So I just briefly mentioned time limits on copyright, right? Copyright isn't forever, but it's usually until the person dies and sometime after that. Patents, they're not forever. They're actually usually only for about 15 years. So with that new law, the patent's only good for 15 years. And think about it, 15 years, that's okay. Because, you know, especially in software, you know, think of the software that's 15 years old. Do you want to use it? No, we're all using the new stuff. Yeah, you don't need to file an application like you do for a patent. And you get to just keep them. Now, how do the trade secrets, how do we protect them? This slide represents the idea that we have employees working in a company, and maybe that company has some trade secrets. They have some ways of doing things that they think are better than other companies, and they are providing a profit to them. And so what they will do is when the employee signs the contract to work with them, they will include a clause in their employment contract which says you cannot disclose our secrets, basically. And if you do, we're going to sue you for so many blah, blah, blah. And the other thing that we'll do, so there's two different clauses that we'll include. You cannot disclose anything that you learned at our company. And then we're going to have a non-competition agreement. Usually what the non-competition agreement is, it's going to say for a period of time, you know, maybe it'll be 6 months, maybe it'll be a year or 2 years, that you won't work in a company which is directly competing with this company. Because what would you do, right? You got all those trade secrets in your head, you're going to take them over there and make money. And of course, that, oh, do you see at the bottom there? You can barely see it. Right? It's copyright 2019, see engage, all rights reserved, may not be copied, scanned, or duplicated. So that's a warning. It's a, and I believe we are in the clear. I think we did pay for this. So the non-compete agreement means that that employee agrees that they will not work for another company that does the same thing. Or they would face some kind of penalty. So does that mean they have to go on a 6-month holiday or something like that? Actually, the way the courts look at that, they do look at it with a bit of, I'll use the word nuance. They look at that and they say, well, it's not really fair that you got this guy who's like an engineer. I mean, all he's done for the last, he or she or he, all they've done for the last 15 years is this particular telecom stuff. And then you can't say that they can't work for 2 years. You got to let them go and work. So we have to sort of look at that with, on a case-by-case basis. People have to be able to work, but maybe they can't work at that company or something like that. So what they'll do is they'll put a geographical thing on it. They'll say, all right, so you agree that you won't work in the same industry within 100 miles of where our office is. So, you were working in, let's say in Silicon Valley with these IT people, and then you leave, you can't go across the street to the other guys that are doing the same job. You're going to go to the other side of the country, or maybe you'll go to another country and you'll go and work there and you'll be okay. Because you won't, because basically the non-compete agreement is that they can't write it so that you don't have a way of making money. I mean, you've invested a lot of time in developing your skills. And those skills, by the way, they degrade over time, right? They perish. So what I mean by that is every month, every year that you're out of the industry, you're losing, you're falling behind. And so if you just can't take 2 years off work if you're an engineer doing that kind of stuff. So you need to be working somewhere. And so that's recognized by the courts. And so they take that into account. Plagiarism. This affects people at schools a lot. Okay, so who's going to be affected by plagiarism? Anybody who writes a book, anybody who goes to university or college or school and writes an essay or writes a report. Plagiarism means that you took somebody else's idea and you put it in your whatever, and you took credit for it. And so what do we do to make sure that we don't do that? Can we not use other people's ideas? Well, sure we can, but we just have to say, this is the idea of so-and-so, and I agree or I disagree, and this is why. But you can't just go to somebody else's report and they wrote that and just copy that and stick it in your report without saying, well, you can't do it. So there's a lot of sort of specific rules for it. But at universities, colleges, and to a certain extent in high schools, I think plagiarism is considered cheating. Most universities, they would have a policy where, so supposing you did a research topic and you presented a thesis, if they found that you actually copied that, they might withhold your degree, or they might expel you from the college. It certainly would be a big scandal. It would be a bad idea. Has it ever happened? Oh yeah, lots of times. And so there are tools to actually help. And I mentioned this to you, I think in the last lesson. There's this thing called Turnitin, which a lot of universities use. And basically every report, every thesis that's turned into the university goes through this Turnitin software, and it searches all of the paragraphs in the report. And if it finds a paragraph like that anywhere else in any of its database, it will put up a red flag, right? And then we get a percentage similarity between your report and somebody else's report. If the percentage gets up around 40%, you're probably talking to somebody about some discipline. Okay, reverse engineering. So the idea there is so we take somebody's invention and we take it home and we look at it and we say, it does this, this, and this. So I'll just make one like it that does all those things, but I'll just make it myself. And you might say, well, yeah, that doesn't sound too bad. Now, if you could go to a really bad extent with this, with software, when you write a program, you write it in your programming language and then you compile it. So what if you could get a hold of a computer system that would take compiled programs and decompile it? Because compiled program, all it is a bunch of zeros and ones, right? Nobody can read it really. But if you could get a decompiler, and apparently these things do exist, if you could get a decompiler, you could go back to the original code, and then you could go and use it the way you want. Well, that would be kind of bad and probably be breaking the law. But there have been court cases where companies have said, well, we looked at their code. We didn't copy it, but we looked at their code to find a way of getting our system to work with their system, for our system to be able to get inputs out of their system, that type of thing. And that kind of reverse engineering has been allowed by courts in the United States. So that brings us to the idea of open source. Now, you may at some time hear about this thing called the LAMP stack. Have you ever heard of that? The LAMP stack, which is Linux, that's L, Apache, that's A, right? At MySQL, that's M, and P is PHP. The LAMP stack is a way for all of those tools that I just mentioned are open source. And so what that means is you sitting at home with no money, but a link to the internet, you can go and you can download a LAMP stack sort of development package. You can download that, and you can go ahead and with that, you can build websites, you can do all kinds of software development, and it's all free and you don't have to pay for it, right? Another one that you could use is like Python, that's free. Python programming, that's not stealing when you download that. They want you to have it. Now, not only do they want you to have those things, but they will actually give you the source code. So I talked about the decompiler. You don't need to go and do decompiling. You can just go and get the source code. They'll let you have it. And so they have some reasons for doing that. It's free. They want to support. There's kind of like, it's almost like a philosophical movement among some IT developers that they want people to have this free software. And I guess the theory, the idea behind it is if we got all these different people working on it, that's a lot of minds, right? 2 minds are better than 1 mind. 1,000 minds are better than 200 minds. The idea being that these people can make changes to the code, and so we actually get a better code. And so I guess they would say that Linux might be in that way better than your Windows software. Because it's open source, and maybe they find when errors are found, they're quickly fixed because we've got a lot of people looking at those, and those people can make those changes, things like that. So open source, it's a nice movement. And as I said, what it means is you have IT development material that's free. And so, of course, a lot of universities use it, right? You find that if you do the programming course here, you're going to be programming probably in Python. Now, I'm not going to say that just because Python is free, that's the reason why we do it, but I'm not saying it's not either. And you'll notice that the database management system that we use is going to be MySQL. And as I said, I'm not saying that the reason we use it is because it's free, but I'm not saying it's not either. So competitive intelligence, this is using the word intelligence in the way that you would refer to like the CIA intelligence, right? Basically spies. So that kind of intelligence. You should have got the idea from a previous slide. If you go sneaking around to other people's workplaces and sort of, or pulling stuff out of their rubbish bins, you know what I mean? That's what they used to do in the past, right? Or copying things off their hard drives and then taking them back to your office. That's illegal. You can't really do that. I mean, that's their secrets. You can't do that. But what you can do is they got a lot of stuff out in the public, and you could take various tools that can basically filter and aggregate that stuff and come up with some trends and sort of figure out what they're doing. So for example, we've got these special tools here, Reportive, Crunchbase, Corey. Corey is about, as far as I know, that's about criminal offenses, whatever, who got funded. So basically by using these database tools that are out there in the public sphere, you could produce some reporting that would tell you a little bit what your competitors are doing. And, in the financial sphere, people are doing this all the time, right? First, in the financial sphere, people have to publish their financial reports. So those financial reports will be public if they're a publicly traded company. If they want to get people to buy shares and stuff like that, they have to publish it publicly. And so what's happening is you have these very smart people that are sitting in offices like in Wall Street or whatever, and they're poring over those reports to figure out what's going on inside that company. And some of those people will be working for a competitor company, and they'll be trying to figure out what's going right and what's going wrong with that company, and how can we compete with them better. So that's the type of thing that we're talking about there. It's totally legal. Nothing they're doing is wrong, but they're trying to get some advantage over the other company using publicly available information from that company. Where it becomes illegal is if you're sort of going into their office, as I said, downloading stuff from their computer systems, that would not be good. So I hope you've got the idea of a trademark. McDonald's has the golden M, right? You can't really use that. You know what I mean? That's theirs. Coca-Cola's got the way it writes Coca-Cola. You can't use that. That's theirs. Now, the idea here is, well, with this particular law, well, you can use a little bit of it. Supposing you're a little grocery store, you can put a Coca-Cola thing outside, because that's the only way you can sell Coca-Cola, right? Let people know you've got it. That doesn't mean that you're the Coca-Cola store, but you can use their trademark in that way if it's going to help you with that little bit of business. And I've mentioned fair use. Yeah. So somebody's saying that you use their trademark in the way that you did your business, but you might say, well, you know what? I used your trademark because I'm selling Coca-Cola at my shop. To be fair, Coca-Cola is not going to sue you for that, but because they're going to give you the Coca-Cola sign. But like some other thing, I suppose, like that. If you're a tourist, and these are just off the top of my head, sorry. But if you're a travel agent, I suppose you could put a sign out that would be the Qatar Airways sign or something like that, And, I suppose Qatar Airways could come along and say, that's our sign. You're not from Qatar Airways. And you might say, yeah, but I'm selling Qatar Airways tickets. And, you guys are making money out of it. So, yeah. So lastly, brings us the idea of the cyber squatter. This was a big thing back when they first started having the .coms. So what I mean by the .coms is when people first started making money on the internet. The idea was there's a few people sitting around saying, there's actually this one case. There was this guy, he looked at that and he said, McDonald's is a pretty big company. I'm going to go and register with this organization, which is called ICANN, which is ICANN has a database which they manage, which is all of the registered URLs. And so he went along to them and said, I want to register in my name, mcdonalds.com. And he did. And the people at McDonald's said, well, what do we care, right? We sell hamburgers. So, I mean, this is back around 1990, something like that. And then as the internet got more traction, where people realized they could make money out of it. I mean, you go to mcdonalds.com now, that's not owned by this guy. It's owned by McDonald's. So he was a pretty good guy, that one actually, because he'd registered their mcdonalds.com in his own name. So he owned it. He was cyber squatting. And McDonald's came along and said, we'd like to have that website. And he says, yeah, okay, that'll be $3,500. He probably could have asked for millions, right? And you have to give the $3,500 to this school or something, so they can buy a computer or something. So there are some good guys out there, I guess. I mean, that's pretty nice of it. I don't know. But I think that window of opportunity is more or less gone. I think you're not going to be able to see. So a new company comes out, I'll just register their name as .com. No, they've already done that. Everybody's sort of got onto that. Okay, so that's it, folks. Any questions?